I'm very sorry to tell you that you're only going to get about the last hour. I did not record the first hour. Uh, I probably need to be taken out, drawn and quartered, and shot at sunrise. uh, anyway, the lecture notes are there. I do suggest you read the lecture notes. You will miss a little bit. Hopefully, you'll get more out of this. Equal Pay Act of 1963 is amended. Simply states that gender may not be used to discriminate in pay rates. Equal pay for equal work, or equal work for equal pay. The act became less significant after passage of the 1964 Civil Rights Act, specifically Title VII. And then Title VII of the Civil Rights Act of 1964 is amended. Now we've gone through this, and then we come to the topic that I mentioned before. Bona fide occupational qualification is probably the best known exception. For instance, I'll give you a couple of for instance here. A state may require that institutions hiring male prisoners be staffed by male guards. This is the bona fide occupational qualification, BFOQ, and this type of requirement has been upheld by the courts. A specific case was in Illinois. A woman sued because she felt like she was being discriminated against, not being allowed to work for the prison that housed male prisoners. And the courts upheld the fact that the government was within its right of saying that it wanted males to be guards for prisons that housed male prisoners. Religious organizations also fall into this category because they can say that to be hired, you have to have a person who is of a particular religious persuasion, simply because that's the way it is. They want people there who follow their religious tenets. Used quite frequently, we don't see a whole lot of those issues coming up. Now, the other pieces of employment legislation, Age Discrimination Act of 1967 protect people over the age of 40 from being indiscriminately fired because of their age. Pregnancy Discrimination Act of 1978, the Immigration Reform Act of 1986, and then the Americans with Disabilities Act of 1990. I'm not going to dwell on those pieces of legislation. There are other important, they are important, but there's others that I consider more important, and we'll talk about each of those a little bit more. This does give you the some of these Age Discrimination Act, and then the next one is the Disabilities Act, and it also extends to mental illness as well. So these things are there. And notice that cancer is considered a disability. Pregnancy is considered a disability as well. You ladies can tell me that you're not disabled when you're pregnant, but when you are pregnant, it's more difficult to do certain things simply because of being pregnant. And it is considered, it does fall under the ADA. The Civil Rights Act of 1991 is also a very, very important piece of legislation, and we're going to have it right here. It made some changes in the 1964 Civil Rights Act and actually strengthened them. Among its most important provisions are that, if you see here on the slide, shifting the burden of proof to companies that are accused of adverse impact discrimination. Now we'll talk about adverse impact a little bit more. So it shifted the burden to the company to prove that they were not guilty of this. Notice that here the big issue is, if I bring a lawsuit, It's known as a civil suit. If I bring a civil lawsuit, the burden, I am the one that has to prove, not the defendant. I am the one that has to prove. But this changed the dynamic. It said that, hey, Mr. or Miss Employer, you have to show that your policies were not discriminatory. So what here is, it's notice that this very burden of proof in a lawsuit's on a plaintiff. That's bringing a suit. That means that it's the plaintiff's responsibility to show that the defendant committed a wrongful act, but not here. So now organizations can try to get employees to, or try to avoid this by having employees sign arbitration agreements. Now, the seniority system may be challenged. You can see that on page 33 in the text. And then it established the Glass Ceiling Commission to determine if women and minorities were systematically encountering barriers in the workplace. So here's a little bit more with this. Adding punitive damages. Now, also the 1991 Act allows jury trials for employment discrimination cases. And I think there's one more. And laws apply in foreign countries. If it's a U.S. company, then they have to adhere to U.S. policies and procedures and laws. In ensuring that selection and staffing policies and procedures are in compliance with the EEOC, Equal Employment Opportunity Commission guidelines, organizations must be aware of adverse impact and disparate treatment. Adverse impact occurs from what appears to be racially neutral employment practices. In other words, it's a practice set up, and if you looked at it on the face of it and said, well, this doesn't harm anybody. Anybody. In fact, what happens is a significantly higher percentage of minorities and other protected classes are rejected for employment, placement, and or promotion. For instance, suppose your organization only hired employees based on internal referrals. And actually, this did happen, and we'll talk about this shortly. This is great because employers know that an employee would not refer someone to be hired if he or she thought that person was a stumble bum. So they're giving you a good qualified, or giving you a lead on a good qualified individual. But if your workforce was totally white, you would normally expect all referrals to be white as well. And this is what happened to Allen Bradley Company in Milwaukee, because all of its referrals were white and it did not reflect the surrounding community. The company was cited for failure to recruit blacks, and I'll talk more about Allen Bradley when I cover affirmative action here in a few minutes. Disparate treatment is a lot easier to figure out because it told you by the very fact of the name, it's treating people differently based on some kind of a discriminatory factor, age, race, ethnicity, whatever it happens. So organizations need to be aware about EEOC guidelines and prevailing employment law. I have to tell you that disparate treatment, by its very self, it's already told you that you're discriminating. Now, I want to stop here and say a second that all employers discriminate. Now, what do I mean by that? They discriminate because they choose between or among people. Get down to two people, they choose one person over another. That's discriminatory action. If both people have the same education, the same skills, the same education, experience, etc., then the decision is going to be discriminatory in some in some way. And what you have to make sure that you do is you don't make that discriminatory decision based upon some factor that you're not allowed to make it on: race, creed, ethnicity, national origin, etc. So I would like to talk now about what I consider to be a very contentious subject in the United States, and we've had several Supreme Court cases about this, and that is affirmative action, which, as I alluded to before, is not a federal law. It is was an executive order. The executive order number was 11246, signed by President Lyndon Johnson in 1935. Most people, well, it probably is a bad term to use, but a lot of people think that affirmative action means quotas. And that's not true. Affirmative action programs may mean quotas for those organizations doing business with the federal government, but likely do not mean quotas for non-government contractor organizations. Now, you're going to work a case for that, and the parameters for affirmative action can be found in the textbook. So when you work the case, please look at those parameters and make sure that you address them when you're addressing the case. Affirmative action, pardon me a second. I'll get you the right page number for that. You can find it starting on page 86 for policies. Affirmative action itself is defined on page 85 in the text. Why should organizations other than the federal government, its contractors and subcontractors, consider affirmative action programs in the first place? And I want to go back here for a second. When President Johnson signed that order in 1965, it applied to those contractors doing business with the federal government that had a contract in excess of $10,000. Not a lot of money. And what President Johnson was, trying to do was to level the playing field for people. He grew up in a hard scrapple area of Texas, and he was a school teacher after he graduated from college, and he taught a lot of folks who were Hispanic. And he saw that they had very, very few means of rising above their station. And so his objective was to do something to level the playing field. Didn't say give these people the job, but to level the playing field so they had equal opportunity. The following that I'm going to give you is taken from Chapter 6, Recruiting, Screening, and Selecting Employees, Wayne Cassio's 1989 text, Managing Human Resources, Productivity, Quality of Work Life, Profit, second edition, published by McGraw-Hill. I use this case. I realize it goes back to this text and this reference goes back to 1989, and it makes it 25 years old. I used this text when I was in graduate school. I have found Cassio's explanation and reasoning for affirmative action the best I've ever read. I've not read anything better than this. Now, I am not talking about a Supreme Court ruling here. I'm talking about Cassio's rationale of why companies would want to have an affirmative action program. He says there are 4 ways to develop legal recruiting policies. Now, I didn't talk about affirmative action here. Legal recruiting policies to achieve a balanced workforce. And the first is he calls passive. Passive non-discrimination. Treat everyone equally in all personnel decisions, but there is no attempt to attract or to actively recruit minorities and or other protected classes. Pure affirmative action. A concentrated effort by an organization to expand the employee pool so that no one is excluded. Now notice, expand the employee pool. Probably better stated, the applicant pool. However, the decision to hire is based on the best qualified individual. Affirmative action with preferential hiring goes a little bit further than pure affirmative action, systematically favors women and minorities, and it's probably best known as a soft quota system. And then finally, pardon me, his fourth, hard quotas. We don't need to explain that. Simply what it says. Got to have so many of this kind, so many of that kind, so many of another kind. Most organizations, government and otherwise, do not like quotas. Passive non-discrimination, pardon me, misses the mark, and this is what got Allen Bradley in trouble. It was cited by the Secretary of Labor in 1968 for lack of minority hiring. Preferential hiring goes against Supreme Court decisions that state personnel selection decisions must be made on a case-by-case basis. Race and sex can be taken into account as one factor in an applicant's favor. This was published in the New York Times, July the 3rd, 1986, pages A1 and B9. B in the New York Times is part of their business section. Of course, that's changed over a period of time. Affirmative action is under fire today in several cases, which I'm going to talk about shortly, and where affirmative action is going to be, I don't know. So this leaves us with pure affirmative action as the best answer. And in the labor market, and this labor market, and our labor market, a free labor market, that can be the only answer. Today, many people believe that affirmative action is passé, that the U.S. has significant laws and sufficient laws in the books to prevent hiring discrimination. Yet, as the Abercrombie and Fitch case will show you, even when we have laws, discrimination is an everyday occurrence in the workplace and elsewhere. I will leave it for you to decide whether or not we need to continue promoting affirmative action. You're free to make a post about affirmative action, but it's not required, although I encourage you to post comments on items of interest that interest you throughout the course. Affirmative action is under fire today, and in fact, the Supreme Court will hear and decide a case brought by a woman from Texas. I'll talk to you about this in just a second. She alleges she was denied enrollment at the University of Texas at Austin due to affirmative action quotas. In an earlier part of this century, the Supreme Court ruled that it was permissible for universities to use race as an admissions criterion. That was a 5-4 ruling, and the court has changed since that time. What I mean there is the makeup of the court. By the way, a criterion, but it could not be the sole criterion. And we're going to give you two cases, affirmative action cases, brought to the Supreme Court, both involving University of Michigan. Now, what happened in this Texas case was the Supreme Court, in essence, I'm doing this from memory now, in essence, did not rule in favor of the plaintiff, but did send the case back to the district court for further review and discussion, and to look at the University of Texas affirmative action plan. The young woman in this particular case went to Louisiana State University and did earn her degree, but felt it had been easier for her and less expensive to go to University of Texas. Now, why is the University of Texas required to have an affirmative action plan? Well, because it's a federal contractor. So it's a sticky wicket. We have a lot of people who do not like affirmative action because I don't think it's very well understood, the purpose of it. We had a gentleman who was elected to the United States Senate from North Carolina, Jesse Helms, for several terms, at least 2, if not 3, and he used a very successful political ad against a minority who was running against him for the United States Senate over an affirmative action thing. And somebody didn't get a job because a minority got it. Well, you know, that's just not the case. But that's what happened, and of course that person was not successful. Now I'm going to look at several cases here for you, and we're going to talk about them more specifically. The Griggs case in week 3, which I think will be interesting. Significant cases, Griggs versus Duke Power, and I said that before, we'll talk about Griggs at length in week 3. Albemarle Paper Company versus Moody. In this 1975 case, it reaffirmed the court's position on the use of employee tests. Tests are often thought to be discriminatory against minorities. Now, please do read the Griggs case, which is listed on page 46, if I'm not mistaken, in the text. Just give me a second here to check that. I think it's page 46. Yeah, page 46. And as I said, we're going to talk about it in week 3. What the decision in Albemarle said, tests must be rated to the position or the job which the company is trying to fill. That performance appraisals are in fact employment tests, and employers must assure that the appraisal is job specific. In other words, that it measures what it's supposed to measure and not measure something else. The onus is on the employer to show that any employment test is job related, and the job analysis is critical in that it can be used to demonstrate the validity of employment tests. Now, with job analysis, we talk about at much greater length later in the course. Washington versus Davis. This case had several twists and turns. The district court for the district court for the District of Columbia, a federal appeals district court ruled for the District of Columbia. Excuse me. The Federal Court of Appeals overturned the ruling, but the district court's decision was subsequently upheld by the United States Supreme Court. The heart of this case was an employment test. And although 4 times as many blacks failed the test as whites, the Supreme Court held that a job-specific employment test could be used in the selection process if it was deemed to be racially neutral, even though it had a negative impact on minorities, specifically blacks. Listen to that wording very, very, very carefully. That the test could be used if it was racially neutral, even though it had a disproportionate effect on minorities. Now, what's very interesting about that case is the majority of the court were made up of what we would consider liberal justices at that time. Justice Brennan was on the court, Justice Douglas was still on the court, and several other people. So the court was probably maybe 50-50. It wasn't one completely one way or another. There were some other ones. Warren Burger was the Chief Justice. Whizzer White was on the court at that time. Byron White's correct name. Justice Powell was on the court. Justice Blackmun was on the court. The latter 2 conservative justices are thought to be. Regents of University of California versus Bakke. Very, very interesting case because it gets to the heart of affirmative action. Bakke was white, twice denied admission to the University of California Davis Medical School because of quote-unquote racial quotas. That is, UC Davis Medical School reserved a certain number of slots for minorities, and Bakke was not admitted even though his grade point average was higher in his medical school acceptance test. Note that prior to the Supreme Court ruling, the California Supreme Court had ruled that Bakke must be admitted and that the set-aside slots for minorities were not constitutional. While the Supreme Court decided in Bakkey's favor, it did not settle his reverse discrimination claim. A lot of times the Supreme Court does that. It punts on certain things. The Supreme Court upheld the general provisions of affirmative action. By the way, this was in the 1980s. Affirmative action requiring federal contractors to be proactive in righting previous discriminatory practices. But these contractors cannot discriminate against individual white applicants. This is kind of like having your cake and eating it too. I am a Supreme Court watcher. I come from a family with a long legal background. Both of our daughters are practicing attorneys. So I pay attention to these rulings. Sometimes I'm really puzzled by how the court decided. United Auto Workers versus Johnson Controls. In this case, this is testing a case of bona fide occupational qualifications. Johnson Control had a fetal protection policy that prohibited women employees from working in the battery manufacturing process with their high levels of lead there. Policy was implemented after 8 women employees became pregnant, and at the same time had high blood levels that exceeded health centers, high blood lead levels. Supreme Court held that the policy to be discriminatory because it was based on gender and did not provide the same protection to male employees. So what it said here was, if you're working in the lead manufacturing, the lead area, the battery manufacturing process, where there's a lot of lead around, and of course lead fumes are very dangerous among other things, that if you were a woman, you couldn't work there because you had, especially after they found out they had high concentrations of lead in their blood, but they didn't offer any protection to men. So that's what the Supreme Court was saying. Now I want to come back here to a couple slides because we're going to talk a little bit, and we'll talk a little later about harassment, sexual harassment. This is Burlington Industries versus Ellerith. Ellerith was a female employee at Burlington who encountered what she believed to be incidents of sexual harassment from her supervisor, and alleged so in a letter to Burlington. Now, the purpose that we need to pay attention to here is she worked in an office that was physically dislocated from Burlington's corporate headquarters. And after she did this, she resigned. She stated that her resignation stemmed from the supervisor's sexually harassing behavior. And Burlington said that it had a policy against sexual harassment, but the district court held that while a supervisor's conduct was reprehensible, Burlington could not have known about it. A federal appeals court overturned the district court's decision, but could not reach a defining consensus. Supreme Court eventually took the case and established the guidelines for sexual harassment. Employers must be aware of these when instituting sexual harassment policies. Guidelines cover quid pro quo, which we're going to talk about here in these slides in a second. Here, the employee suffers tangible damage because I'm going to use C because in most cases this is what happens, although there are some other ones. Because quid pro quo is a Latin phrase which loosely translated means this for that. So what the harasser is saying is, you have to give me sexual favors or you don't get promoted or you don't get a pay raise or something else. And if you do that, then I'll see that these things are taken care of. Hostile work environment is a scenario comes into play when actions are both severe and pervasive. Employers are liable for supervisors' behavior when they result in adverse employee actions against the employee. In other words, you didn't do what I asked you to do, or you were in this sexually harassment environment, and I'm going to retaliate against you, and may offer what is termed as an affirmative defense when they can demonstrate that they had a policy against sexual harassment in place, that supervisors knew of the policy, and that the company took precautions to prevent workplace sexual harassment. It's very important to pay attention to this because this is what's going to be found when you get to the Torres versus Pisano case. Now, here's what sexual harassment, or what harassment is. This is persistent annoyance. Use of bad language, improper words, could be pictures, could be music, could be gestures, could be other types of innuendos. Now, this is not quid pro quo. This is entirely different than quid pro quo. It's directed at an employee because of his or her gender and is known as sexual harassment. Now, interestingly enough, the court did rule in Oracle versus Sundowner, I think that's the case, that it could be male on male. And the reason I use that is because that was the case. Now, here's some other information about sexual harassment. Really have to be careful about this. This is unwelcome advances and all sorts of things of that nature. We just can't really, we have to, first of all, we have to have a policy. Employer has to have a policy. And the second thing is the employer has to make sure that that policy is transmitted to each and every employee. And it's always good to have follow-up training on a rather continual basis. So something that is very important, needs to be paid attention to. I'm going to come down to the quid pro quo slide just so you can see it. This says something for something. I think it's really what I said, this for that, but it doesn't make any difference. So it's illegal to do any of this. And say, well, if you want to get ahead, you have to perform these sexual acts for me or sexual behavior, or pay attention to some of the sexual things that I'm doing. And if you don't, then you don't get promoted, you don't get pay raise, you don't get bonus, et cetera, et cetera, et cetera. And then this is the hostile environment, which we did talk about a little bit. Behavior that causes someone to feel uncomfortable. This is not quid pro quo. It's not this for that or something for something, but it interferes with people doing their jobs, etc. Now, let's talk a little bit here about two cases of affirmative action, both from the University of Michigan. First is Grutter versus Bollinger, and the second is Gratz versus Bollinger. Bollinger was the president of the University of Michigan at that time. He's now at Columbia University in New York. In the first case, the University of Michigan was filed against the University of Michigan Law School. In this case, the Supreme Court decided that race may be used as an admissions factor, but could not be used as a racial quota to assure a diverse student body. Now, here again, the court is having it both ways. It can be used as a as an admissions criterion, but it can't be used to assure racial diversity. So, first, was a diverse student body a compelling state interest for Michigan? And the Supreme Court said yes, that it was. But it was so narrowly defined as not to be a deciding admissions factor. So you can see the Supreme Court said, yeah, diverse student bodies state's best interest, as long as race was not the deciding admissions factor. In the Gratz case, race was the deciding factor. This was for University of Michigan's College of Literature, Science, and Arts. And it awarded 20 points on the admissions form that they used, if you will, out of a possible 100. And so, in effect, every minority high school graduate was almost sure of being admitted. In this case, race was the deciding factor. Justice Sandra Day O'Connor, who's now retired and was the first woman on the United States Supreme Court appointed by President Reagan, 1982 or 83, I'm not sure which year. She wrote the majority opinion in both cases. Does it seem like the court spoke out of both sides of its mouth in these two different cases? Well, no. In case one, it said that race could be used as an admissions criteria to help assure a diverse student body because that was a compelling interest of the state of Michigan. But it said in the Gratz case that race could not be the deciding factor. And if you're getting 20 points for admission simply because of your race, and overall out of 100, then it's become a deciding factor. So you can use race as the deciding factor, but it can't be the sole, excuse me, as an admissions factor, but it can't be the sole or deciding factor. 20 points made it a deciding factor. No questions about it. Now, Supreme Court did hear a case, that one I talked about was last year. I don't think this is going to go away. I think we'll see more of this. It seems to me that Justice O'Connor thought that by the time we got to 2025, we would no longer need affirmative action. I'm not quite that optimistic. I want to tell you that. And obviously, I don't feel like I've ever been discriminated against in my life. I may have, but I don't know about it. Much different than women and much different than minorities. Not been in that situation. I think we need some protection. That's a personal opinion. You do not have to agree with me. Certainly what I would say to you is if you take a different position than I do, just don't say, well, I don't agree with you. Say why you don't agree with me. And we can have a nice little dialogue about this and perhaps both learn from what the other person had to say. So as I mentioned, this is not a complete list. There are more cases listed in your book. These are important, I think, because it gives us a wide spectrum of important cases and decisions that the court has, important cases the court heard and important decisions that it has rendered. Now we're going to talk about Chapter 4, which is Equal Employment Opportunity. And it covers not only equal opportunity employment compliance, but it also covers affirmative action. We discussed affirmative action. I'm not going to revisit this. The Equal Employment Opportunity Commission was implemented after the Civil Rights Act of 1964, specifically Section 7, and signed into law. It actually started out as EEO, Equal Employment Opportunity, and that was a piece of the 1964 legislation, and then the EEOC was established to assure employers were following the law. We'll examine some of the issues of EEOC, but first I'm going to speak of other important policies. EEOC, in conjunction with several other federal agencies, publishes the Uniform Guidelines on Employee Selection Procedures. An important clarification of the guidelines defines employment tests, which the court has ruled on, as you know. Now, the complete definition can be found on page 73 in the text. In essence, the guidelines state any factor used in employee selection is considered a test. That goes a little bit further than what we said before. Before we were talking about tests for employment, and we were talking about performance appraisals. This is any test. Any factor used in selection is considered a test. Tests don't require validation, but if employer practices or policies unfairly discriminate against minorities and other protected classes, causing adverse impact, they are considered illegal. Employers have two methods available to demonstrate employment procedures and policies are not discriminatory. It gives you some information here about EEOC. It's charged with to do this, and then Here we have talking about discrimination. What's employment equal? What is equal employment opportunity? It means that everybody who is qualified, notice the term I used, everybody who is qualified has an equal opportunity of selection. I didn't say any particular race. I didn't say any particular protected class. I didn't say anybody with a certain amount of education or anything else. I'm saying everybody who is qualified has an equal opportunity to be selected. Now let's get back to this employers being able to show that their practices were not discriminatory. They can demonstrate that the tests used are valid and that they are predictors of success on the job. There are some people that will tell you that tests don't predict success as much as they predict failure. And of course, that's acceptable. If the test says applicant A is going to fail because he or she didn't know the job, and applicant B can because their success rate is pretty high, that's okay. Furthermore, employers must show the relationship is so strong that failure to use it would cause the employer's training costs to be exorbitant. In other words, what it's saying here is we're using the test as a discriminator. Nothing wrong with that, as long as everybody takes the test and it's neutral, okay? And if we don't have this test, then it's going to cost us a lot of money to train these people coming in. Second, firms can use BFOQ, bona fide occupational qualification. This presents a great challenge to employers because courts have interpreted BFOQ on very, 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 very narrow parameters. For instance, because most women cannot lift a specified weight does not mean that all women can be excluded from employment consideration. In fact, many BFOQs were actually used as a basis to discriminate in employee decisions. And I have one a little bit later on in the course that I'm going to talk about. Very, very interesting case. To prove intentional discrimination, however, the plaintiff must establish a prima facie case involving the following elements. He or she is a member of a protected class. They applied for or were considered for the job for which he or she is qualified. That he or she suffered adverse employment decision, not hired, etc., and the position remained open and the employer continued to seek applications with qualifications similar to that the plaintiff held. Now, how do we get to EEO and EEOC? Three things occurred. I'm going to talk about these and expound on a little bit more a little bit later. Societal values changed. The economic status of minorities and women increased, and the emerging role of government and government regulations. Society, at least we in the West, believe that people should be rewarded based on their qualifications. Well, that's what we've been talking about. That was not the case for most women and almost all minorities. In the early 1960s, we witnessed horrible treatment of blacks in the U.S. South, and as a result, the government was prodded into taking action. And the result was the 1964 Civil Rights Act. Economic inequality in the black community and economic status of women also forced the government to act, we sort of alluded to before. Two issues that EEOC is concerned about in employment decisions: adverse impact, disparate treatment. We're going to talk about those a lot more. Adverse impact, unintentional discrimination, occurs when racially neutral practice has the effect of disproportionately excluding minorities, which we've mentioned before, and we'll mention again when we get to the Griggs case. I know that this may sound like I'm making a big point of this, but this is the subtle discrimination that so many people in this country faced, and it still continues. Disparate treatment, we know that disparate treatment is a lot easier because we already said this. We're treating some people differently than we treat somebody else. That's the meaning of the word disparate. Often the EEOC, however, is seen as coming down on the side of the employee rather than that of the employer. We need to view this through the lens of the employer having more resources than the employee, and that the EEOC is there to protect the rights of the worker. That's true. But I do have a short personal story to relate that gives the other side of the coin. I worked the beginning in 1998 after I left the United States Army. I worked for a small nonprofit organization here in the greater Cincinnati area. And we had two janitors. We had, by the way, when I first started working there, I was director of human resources. And when I started there, we had two janitors. One janitor worked during the daytime. We had a adult daycare center, and so we had to have a janitor there during the day, and then we had this janitor at night. And I must confess to you, when I started there, I didn't understand why we had two janitors, because I would come in the morning and I didn't see much difference than when I left the day before. Now, and it's very important to keep this in your mind, because our janitor came in early in the morning. The day janitor came in early in the morning because we had clients that started arriving at 6:30, and she worked till 3 o'clock in the afternoon. Our business day ended at 4:30. So when I'm saying that I didn't see much difference when I came in the morning at 8:30 from what I left the night before, was because the day janitor was still going around doing her job at that time, and trash hadn't been emptied and stuff. So why do we have to have a janitor at night? Well, we decided, our CEO decided that we were going to eliminate the night janitor position. Notice I used the term eliminate. I did not talk about firing or doing any other kind of employee action. We were going to eliminate that position. And so we did, and we called the janitor on the phone and told him not to report for work, but to make an appointment with his supervisor. Well, instead of making the appointment, he showed up at night and found two minorities. It happened to be a husband and wife couple who were from Nigeria, I believe, and they were African country, doing janitorial work. So again, instead of talking to his supervisor, he went to the EEOC and filed a reverse discrimination suit and under the Age Discrimination Act, because he was over 40, and he alleged that in doing this, that we had no grounds for firing him. Now, he said firing, and of course we didn't do that. We eliminated the position, and that his work was satisfactory. Well, it took me about 4 weeks or so to compile the necessary evidence that we needed to refute the charge. We were able to prevail because we could show that he was not fired. As I have repeatedly stated, his position was eliminated, and that the company hired a contractor to complete the janitorial duties. We did not replace him. We hired a contractor to take care of those janitorial duties. Other side of that story, that didn't last very long. People who were there were, I don't know what, they had some problem with the contractor, and then we just kept one employee as a janitor, and that worked out just as well. But we were able to show that, in fact, his work was not satisfactory, because we had statements from his supervisor showing that he had been given direction on things to do that he hadn't finished, and that she had talked to him on numerous occasions and counseled him, etc. And so my point here is that the EEOC is there to assure compliance with the law and to protect both the employer and the employee. Yes, we do think of EEOC as being on the side of the employee more often than on the side of the employer, because for the most part, suits are filed or actions are brought by employees and not by the employer. And so we do find that. But in this particular case, the EOC looked at everything we had. We had documentation about unsatisfactory performance and the fact that he'd been counseled, and that we had not fired him. We had eliminated his position. So that brings us to the end of what I want to cover this evening. We spent here just about 2 hours. I do apologize for getting the recording up late, but I will get that up for you tomorrow. Lecture notes are posted. Again, my error. Unfortunately, it's not the first time I've done this. I'm laughing at myself, not that it's humorous. I remind you, there's no specific written assignment this week. There are 2 forum posts due next week, the Abercrombie and Fitch case and the So What's Affirmative Action. And then you're asked to read chapters 1 through 4. I do want to tell you thank you for your attention. I will have the lecture uploaded tomorrow. It takes me about 10 minutes or so, so I usually say I'll have it on by approximately 9:30. Thank you for your attention, and good night.